All right. Well, the end of the day wrap up. We had three witnesses today. Witness 9, 10, and 11 in this trial proceeding. Well, sorry, I just got a funny text from a friend of mine. All right. So the end of day summary for the Christian Schurr trial, murder trial over the death of violently non-compliant suspect Patrick Lyoya. Day two of this trial. We had three witnesses today. Witnesses 9, 10, and 11 in these proceedings. The first witness was Brian Childs of Axon. Axon is the company that makes the Taser 7 deployed by Officer Schurr against Patrick Lyoya. By the way, all three of these are state witnesses. We're still in the state presenting its case in chief, so the defense has not called any witnesses yet. That'll happen after the state rest. Brian Childs of Axon, the maker of the Taser 7 used by Officer Lyoya and ultimately seized by Patrick Lyoya to use against the officer, which ended up with the officer shooting Lyoya in the back of the head, was a fantastic state witness for the defense. He was amazing. He talked about all the ways in which a taser can inflict death or serious bodily harm, especially in the hands of an untrained individual, like violently non-compliant suspect Patrick Lyoya. He talked about all the ways that it can induce incapacitation, even when the cartridges have been deployed, just by the wires laying on the ground and the device being used in stun mode. He talked about the many ways that the device in stun mode could be used in stun mode to inflict serious bodily injury to various parts of the body, to the face, to the eyes, to the neck, to the groin. He was fantastic. All of these are applicable to Patrick Lyoya's use of that taser on the officer. He talked about how it's relatively simple for an untrained person to activate the device, either in probe mode or drive stun mode. Just pressing the trigger is enough. The thing is shaped like a pistol. Patrick Lyoya had it in his hands like a pistol. The trigger is right there. The easiest thing in the world for Patrick Lyoya to do would be press that trigger to activate the device. Officer Schurr could readily have been subject to neuromuscular, I can't believe I'm blanking on the I. I'll call it neuromuscular lockup, been immobilized, and this witness, Brian Childs, testified if the officer is immobilized, he can no longer defend himself or his equipment, including his service pistol on his belt. Neuromuscular incapacitation. Thank you. Thank you. So yes, Patrick Lyoya wielding that taser. You'll note that Patrick Lyoya did not achieve control of that taser and throw it into a bush. He wasn't simply trying to save himself from application of that taser. He was keeping that taser. What's the only reasonable inference for Patrick Lyoya to get that taser in his grip in the manner to deploy it and then begin to roll over towards the officer on his back? There's only one reasonable inference, and that is to use that taser against the officer. And if he had used it against the officer, there's every reason to believe it would have subjected the officer to neuromuscular incapacitation, left him defenseless against someone who'd been violently fighting him for 3 minutes, and left him unable to defend his pistol from being seized and used against him. What a fantastic witness. He mentioned even just like the wires, the probe wires in the grass, just laying in the wet grass. That alone, if you're also subject to drive mode, could inflict neuromuscular incapacitation. He talked about the fact that, well, sure, the optimal distance for these short range darts is 4 feet, but they can be used at much closer distance, even a foot or two. Then we saw a police academy video from the Grand Rapids Police Department. I think it was a clip showing this officer, Christopher Schurr, using a taser in a close contact form. So shooting darts into the back of a dummy from maybe a foot away, and then moving the muzzle of the taser to the lower legs to do a drive stun so that the current would run up through the leg and achieve neuromuscular incapacitation. This is all trained. This is an appropriate and known application of the taser that Officer Schurr would have been subject to once Patrick Lyoya had successfully secured possession of that taser. All the many ways, there are many ways in which use of a taser can inflict death or serious bodily injury if it's fired at the face, if there are combustibles in the area, certain areas of the body. It's safe because the people who were supposed to be using it, the lawful users, police departments, civilians trained and licensed in its use. And by the way, without a license, this taser possession is a felony in Michigan. So Patrick Lyoya, the moment he took possession of that taser in his hands, was committing yet another felony. Not to mention that he took it from the control of a police officer, which is yet another felony on top of the ones he'd already committed. And these are felonies of violence. The state likes to say, well, he wouldn't even know how to use a taser. No, it's very easy. It's just like a gun. You press the trigger. The only complicated part is it has a weird thumb safety that on a pistol, well, you have to flip it up. If you don't know to do that, the gun won't operate. But the safety had already been flipped up by the officer when he initially deployed it. And once it's up, it stays up. There was literally nothing more complicated for Patrick Lyoya to do to apply this taser against the officer, then turn towards him, which he was doing. We can see it in the video, rolling towards the officer and pressing the trigger. Someone's going to tell me that Patrick Lyoya wasn't smart enough to do that. I mean, he may not have been, but there's no reason we require the police officer subject to that use of force to presume he's too stupid, that Patrick Lyoya is too stupid to depress a trigger. Amazing. So that Brian Charles was a fantastic state witness for the defense. Great stuff. And because he was, the defense did a good job on cross. Really good job on cross. Very impressed by the defense. But they had an easy witness. The next witness was not so easy. The next witness should have been easy, should have been a breeze. This hack, this police-hating hack, Seth Stoughton, was a cop for a hot minute, took 10 years to get through college, then went to law school and found this grift, found that there are Soros-financed prosecutors who are desperate for expert witnesses who will say anything to railroad a cop into prison. Seth Stoughton is that expert. Whatever decision the cop made, it was the wrong decision. In this case, foot pursuit of a fleeing suspect, the wrong decision. It's always the wrong decision. The decision to use deadly force at the end, wrong decision. That cop was facing no threat of imminent death or serious bodily injury. That's not what we heard from the actual taser expert, Dr. Stoughton, PhD, law professor. This guy is contemptible. He was in the Kim Potter trial. He was in the Derek Chauvin trial. There's no decision a cop could make where he ultimately won't find the cop to be at fault. Every single time on the most ridiculous bases. Foot pursuit. Foot pursuit means that this cop lost the privilege to defend himself against a lethal attack? I think not, sir. He drank 10 gallons of water on the witness stand. Obviously, even he was uncomfortable with the BS he was spewing forth. But here's the tragedy. When the defense had this guy, Seth Stoughton, on cross-examination, they blew it. They absolutely blew it. They were not prepared. They were not sharp. They let this guy filibuster and bluster and conflate terminology and pretend ignorance and hide behind technical jargon. The issues here are not complex. The legal issues are not complex. The use of force issues are not complex. They let this guy get away with using nothing but the barest of speculation for arguing why Officer Schurr was in the wrong and should be in a cage for the rest of his life, but demanding that any explanation consistent with the officer's lawful use of force required insurmountable amounts of evidence. We have to have proof for this officer to have been right. But for him to have been wrong, we can imagine any scenario. Maybe the passenger in the car gets out with a gun. Was there any indication the passenger was hostile? Any indication the passenger had a gun? Maybe there's evidence in the car that would be lost. because the officer engaged in a foot pursuit of the fleeing suspect. Is there any evidence that there was evidence in the car that needed to be preserved? No, utter speculation. Maybe the passenger would have slid over into the driver's seat and driven the car away, and then you would have lost the imaginary evidence. By the way, then he would no longer have been a threat to the officer, right? Because he would have driven off. The unbelievable amount of speculation this defense did not call this witness, Seth Stoughton, on was absolutely outrageous. They should have gutted this guy. Unbelievable. The foot pursuit was fine, except for the last 2.5 feet of it. That was the big problem. You're supposed to chase the guy, but not catch him. Don't catch him. Just jog after him. Wait until other officers maybe eventually arrive. Unbelievable. What else? Completely contrary to the testimony we heard from the actual expert on the capabilities and risks of a taser that we heard from Brian Childs, the actual expert from Taser. This guy was snarky. He was overreaching. His conclusions were ridiculous. The basis for getting to them was ridiculous. And a really skilled cross-examiner would have gutted this guy and should have. And Christian Schurr deserved that. Any criminal defendant would deserve that. They had this guy's expert report. They've probably had it for months. They should have gone over it with their own expert well before the trial. Where are the vulnerabilities here? How can we bait this guy into traps? There should have been one trap after another trap after another trap. This guy should have left that witness stand eviscerated. And that didn't happen. And that's a bad thing for Officer Schurr, because the jury may well walk away believing what this guy said after they heard from the Axon guy, right? It'll be testimony that's more recent. And all these misrepresentations will be baked in to the prosecution's closing argument at the end. One of those lawyers, one of those defense lawyers should have had the full-time job of doing nothing but preparing for this witness. They've got 3 defense attorneys there. They could have sent me the report. I mean, I would have charged them, and then I wouldn't be able to cover the trial. But they should have sent me the report. I could have scripted out the cross for them. It's too late now. This is one of the things about a trial, folks. You have to get it right in the moment. It's not a best of 7 games scenario. It's the Super Bowl. After time's run out, you don't get to do it again. You have to get your arguments, you have to get your cross on mark in the moment. Or you're left with what? A desperate hope for an appeal? Appeals are for losers. They had this witness. Now was the time. The Germans don't get to try the Battle of the Bulge a second time. It's over. They had their chance. Crazy. What a wasted opportunity. Unbelievable. What a wasted opportunity. And they did a lengthy voir dire of this guy. Now listen, it's not hard for someone to qualify as an expert. I don't think they could have kept him out of the trial. But they should have done a better job of constraining what he'd be allowed to testify about. I don't believe for a moment this guy is an actual use of force expert. He was a cop for 4 years. I think one of those was in headquarters. He wasn't on the street. He's not getting into fights. And that was 20 years ago. When was the last time he was even on a mat rolling with someone against resistance? Use of force expert, my ass. When was the last time he deployed a taser in a moment of crisis? Ever? Has he ever? Why didn't the defense even ask him that? When you were a cop, how many times did you deploy a taser against a non-compliant suspect? Ever? He says he drive stuns himself to impress us all. But the risks of the taser are a drive stun to the eye, to the larynx, to the groin. Does he let his students drive stun him there? Unbelievable. I'm a little worked up about it. What a wasted opportunity. And then we have this last witness whose name is Nicholas Bloomfield, the cop from New Mexico. Bloomfield, New Mexico, same name. Ha ha ha. I made a joke about it. I think somebody in the comments looked it up and posted. They have like a 22-man department, 8,000 population city. There's a lot of people out there who are well-credentialed. They begin to acquire credentials, certificates they can hang on the wall. Like, I'll give you an example. Me, I've been an NRA certified instructor for rifle, pistol, and personal protection for maybe 30 years. How many students do you think I've instructed in rifle, pistol, or personal protection in the last 25 years? Zero. I keep the certificate because I'm fond of it, but I would never hold myself out as an expert in rifle, pistol, or personal protection 25 years after I stopped effectively training just because I have a certificate on the wall. Use of force expert. It's all academic book reading for these people, and they're judging a man who is fighting for his life in the real world, not in a book, not at a conference, not hanging a certificate on the wall. Nicholas Bloomfield. So he's on direct by the state, and the state is having him elicit all kinds of academic reasons why the use of the taser was inappropriate here. You know, if only Christopher Schurr, when he was fighting with 0.29 blood alcohol level, much larger, much stronger, Patrick Lyoya, no one's coming to his aid. He's called for backup twice. No one's coming. People are standing around watching him lose this fight for his life. If only Patrick Schurr had opened up a book to confirm that it's best to shoot the taser from 4 feet away, as if he had 4 feet to work with. Oh, just disengage, just create distance from the sun drive, and then you don't have to worry about it, said Seth Stoughton. As if you're entangled with someone in a fight who has the stun gun, the taser in their hand. You're going to be able to outdistance them before they can bring that to bear on you? How do you know that? How does that work? Have you ever tried that? Anybody who grapples, no, it's not a karate movie. You don't just bounce away like a rubber ball. You have to untangle yourself from this person. And meanwhile, they're bringing the taser to bear. Just imagine you had a magic marker and you were replicating this fight. And you were playing the role of Patrick Lyoya. And you wouldn't be able to touch that person with the tip of the magic marker because that's all it takes. This guy, Bloomfield, says, well, Taser says you have to be 7 yards away. What? What? The actual Taser company expert indicated 7 yards was like the furthest distance you would use a Taser. Taser recommends 7 yards. I guess Taser would recommend 100 yards because then you don't have to use it. You're not being threatened. But the nearest effective range of the Taser was 22 feet, if I recall correctly, maybe 24. The long range was 7 yards. And they specifically include a cartridge for 4 feet. And they train in a method to use it at contact distance. Just a joke. So I haven't seen yet what the defense is going to do on cross with this guy, Bloomfield. But frankly, I think he's going to be tougher for them than Stoughton. Stoughton he comes across as a hack. He opens himself up to attack by his ridiculous conclusions and his demeanor. His demeanor is unlikable. At least I don't like him. if you haven't guessed. Bloomfield is just so boring. He just kind of adds mass to the prosecution's narrative. I don't think the jury's hearing a word he's saying. I can barely listen to him. He's so flat and so boring. But it's another guy talking for the state about how Schurr did it wrong. Absolutely horrific. All right, folks, that's my wrap up. I will post it up as I'll cut this out and post it up as a separate upload on YouTube for people who just want to see like 15 or 20 minutes of me yelling about day 2 of this trial. I don't think I'm going to do a third show today on political analysis as I've been doing, but I will. If I don't do it tonight, I don't think I will. But if I don't do it tonight, I'll do one in the morning before we start the trial. I'll do a live stream very early in the morning, probably about 8 a.m. Eastern time. The trial starts at 9 a.m. Eastern time, so I'll be here for that. And of course, all the live streams you can always watch as video on demand as well. If you like our stuff and how we do it, I would like to ask you to please hit that subscribe button before you sign out today. Our goal is 1 million subscribers, and we did, in fact, hit 210. We hit 210,000 subscribers today. Thank you so much, and a couple hundred more towards 2011. That is absolutely awesome. I can't tell you how much I appreciate your support. Couldn't do any of this without all of you. And I also have our book. We're making our book available for free to all of you. Law of Self-Defense Principles, our handbook to making you hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Check it out on Amazon. It's 5-star rated. Don't buy it on Amazon. They'll charge you $25 for the book plus shipping and handling. We only ask you to cover the cost of shipping the book to you. It is a fantastic book. People in the comments will tell you. If you already have a copy, get a second one. It's only shipping and handling, folks. Get copies for people you care about. Your family, your friends, your work colleagues. They will love it. It's all in plain English. We translate all the legalese. Most people read it in an afternoon. We just ask you to cover the shipping and handling. We give you the book for free. Get it at lawofselfdefense.com/get the book. Get the book. lawofselfdefense.com/get the book. I promise you, you won't regret it. I promise you. You have my word. All right, folks, until tomorrow morning, then, I will sign off. Thank all of you for being here. And until we meet again, I remain attorney Andrew Branca for the Law of Self-Defense. Stay safe.